I call Reno Tirikatan.
Thank you, Mr. Chair. Thank you. I just wanted to add another contribution at this committee stage, sir, because we have heard a lot about this bill is about data protection, and it is indeed. But what hasn't been covered within the legislation is actually how that data will be protected. We don't know. In fact, under the legislation, sir, we are permitting the Director-General to be able to freely disseminate and share this protected data among MPI officials. Well, we made an amendment to Section 74, or Clause 74, in that regard. But there are further provisions in Clause 74G, where it outlines situations where the Director-General may disclose and use confidential information. And in particular, if we look at sub-clause 4, it states that the Director-General may disclose the confidential information to one or more of the following persons, and I'll just go through them. A government department or statutory body, for the purposes of that government department or statutory body. That's pretty broad, you know. An advisor for the purposes of obtaining advice about the agricultural compound to which the information relates, the World Health Organization, the Office International des Espèces, and the FAO, Food and Agricultural Organization. So, sir, what I'm saying, though, is that this is about protecting data. Yet there is, and that data is held and to be kept confidential, and it is the responsibility of the Director-General. And there is, the legislation provides that the Director-General may disclose and share that confidential information to quite a number of bodies. So I would like to ask the Minister exactly how does the Director-General intend, or how does he indeed keep that information confidential so we can give the agrochemical companies and all of the other applicants the assurance that the commercially sensitive data that they are placing with the ministry is indeed protected? Now, I don't, please, I do not want this to be seen as I'm questioning the integrity of people within MPI. I think that the public of New Zealand have a right to know exactly how does the Director-General protect this information. Who within MPI has access to that information? We've heard about a lot of hacks recently, a lot of hacks, you know, and goodness knows surveillance and everything that's going on. And within government. But this is a very serious point that I raise. Companies, yes, it's great that they are getting an extended period of data protection, but how indeed is their data being protected when this legislation permits the Director-General to freely use his own internal officials and external organisations, any other government department that it might impinge on? How will that data remain confidential? How does it remain confidential so it actually lives up to what the purpose of this legislation is? So it's good that we can actually say we apply it in law, but we do not want companies to, you know, feel that, you know, it may not be protected. So, you know, I believe it's a fair question to ask the Minister. How will the Director-General ensure that the data is protected so it can give confidence to the applicants and companies that will be, you know, hopefully adding to the richness of the agricultural compounds and veterinary medicines across our primary sectors? How indeed is that data being kept confidential and safe so that it can't get into other competitors' hands, other industry rivals who have ulterior motives, because ultimately they won't want to make money. They don't that they want to devise good things, but they want to make money out of it. And they need confidence that our Director General is going to keep it safe. Thank you, Sue.